Welcome back to Real Clear Radio Hour, brought to you by the Competitive Enterprise Institute. I'm your host, Bill Frezza. Joining us for the second half of our show is elementary school teacher Rebecca Friedrichs, along with Terry Pell, president of the Center for Individual Rights, representing Rebecca and other California teachers in their efforts to free themselves from being forced to support the teachers' union. Rebecca, welcome to the show.
Thanks for having me.
Terry, thanks for joining us.
Glad to be here.
Rebecca, you've been in the news lately, but before we dive into your Supreme Court saga, tell us a bit about your background. You've been an elementary school teacher for almost 30 years now, and so was my mom and my sister, so classroom stories were always part of our family life. What attracted you to the profession?
Well, I decided to go into teaching because I have a great love for little children, and I also had some really inspiring teachers myself when I was young. And they gave me a great love for learning, and I wanted to pass that on to little children as well.
So what grades do you teach?
I currently teach third grade. I've taught kinder, first, second, third, and fourth.
We all remember the teachers who touched us most. My mom is 84 now, and believe it or not, she still gets contacted by former students telling her how she changed their lives. But Mom also talked about the impact of tenure on protecting teachers who probably didn't belong in the classroom. Everyone knew who those teachers were, but there wasn't much that could be done about it by either parents or the principal. Have you seen much of that across your career?
Yes, unfortunately, I have seen that problem throughout my career. And in fact, the first time I saw it was when I was a student teacher. I was learning from an outstanding master teacher, but next door to us was a teacher who, in my opinion, was abusive to her little students. These little first graders every day would have to deal with this woman who would scream in their faces and grab their arms and yank them into line, and who was just very objectionable. She always had a frown on her face. And when I asked my master teacher what we could do about that, she sat me down and gave me a lesson on teachers' unions and teacher tenure, and I was shocked that teachers were asked to pay any sort of organization that would protect teachers who were actually bringing harm to children.
Well, you know, the smart parents eventually figured out who those were. It was funny listening to my mom. The word got out in the community. All the parents wanted to be in her class. There were other teachers that, you know, parents knew to avoid, and the parents who didn't know any better, those kids ended up getting stuck in those classes. And there just wasn't much people could do about it.
That's right. It really is a shame. In some school districts, parents can make requests, and some they cannot. And pretty soon you run out of spaces, and someone has to be in that classroom. So sadly, there are a lot of children across the country who are placed in classrooms with teachers who really shouldn't be there any longer, and I just think that's wrong.
Now remind us, is California a right-to-work state or a forced unionism state?
California is a forced unionism state.
So were you obliged to join the union in order to get or keep your job?
I'm not forced to join the union, but I am forced to pay the union fees. If I don't pay the fees, then I lose my job.
And how did that come about?
Well, it's a forced unionism state. I don't know all the history of it, but I do know that the unions have monopoly bargaining control. And if you have a job in a public school district that is unionized, you are forced to pay for that representation, whether you like it or not.
Terry, what's the legal theory behind that?
Well, a number of states, 23 of them, have passed laws that require all public employees to either join the union or pay agency fees that amount to 3/4 of the dues that they would ordinarily pay to the union. The rationale behind this is that the unions say they have to have everybody, be part of the union. Since the union represents everybody, they feel or argue that it's only fair that everybody pay what the union calls their fair share of what it costs to represent them. Again, as Rebecca emphasized, though, you have an obligation to pay these fees whether you agree with the union or not, whether you want to be represented by the union or not. There's just no free choice in the matter at all.
You know, my mom never earned outsized financial rewards while she was teaching, but it was great having her home with us after school and during the summer. And the best part of our comp plan turned out to be her pension check, which is frankly enormous. You know, the taxpayers in her district may not be celebrating, but Mom sure feels she got her money's worth out of her union dues. Does that kind of personal math still hold for teachers in California?
I think a lot of teachers are very appreciative of that sort of pension support, but I think a lot of them don't understand that because we have the type of pension program that we have, defined benefit plan, our pension is guaranteed and paid for by the taxpayers. So it's actually caused a lot of problems within our communities and bankruptcy and those sort of things. And I think a lot of teachers don't understand that and would be willing to go with different types of pension plans if they knew that their pensions were causing so many problems within the community.
But there's not a lot of choice then. Is the union in charge of deciding what kind of pension you get?
That is correct.
So how did you get into a beef with your union in the first place?
Well, I mentioned what happened when I was a student teacher, when I witnessed what was going on with that abusive teacher. So I was always a little nervous about the union from the beginning. About my third year of teaching, I was approached by the union and told that we all needed to fight against school vouchers. So I started researching school vouchers, and I decided I was for them. I thought they were a really good idea. So I was shunned because I didn't want to do door-to-door and phone banking and all of that for the union. I didn't want to be their boots on the ground. And I just found throughout my entire career that I was almost always on the opposite side of the union in educational issues, in political issues, in collective bargaining stances. I almost always disagreed with them.
And yet you still had to pay them dues.
That is correct. I do.
So why did you turn to litigation to change the state of affairs?
I actually tried to change things from within. I served as a union leader on my local union board. I actually served on the board for 3 years, executive board. And every time I would bring a concern to the executive board as a board member, I could not make my voice heard or the voices of my colleagues heard. For example, we had some teachers who were going to be laid off. And I went to the board and I said, look, I have teachers on my campus who would like to suggest taking a small pay cut to save the jobs of their friends and to keep class sizes lower. The union would not listen to me at all, wouldn't have the conversation. I kept bringing it up over and over and over, and they finally said to me, look, Rebecca, don't worry about those teachers who are being laid off. We're going to take care of them. We're going to give them a class to teach them how to get unemployment benefits. And my jaw dropped. I said, they've been paying you $1,000 a year for representation, and you're going to teach them how to get unemployment? They want to teach, and their students want to have them as teachers, and the parents love them, and they're doing a great job. I was shocked and mortified by that. And I ran into those sorts of things over and over again.
So, Terry, how did you and the Center for Individual Rights enter the picture?
Well, we follow the Supreme Court closely, and a couple of years ago, the Supreme Court issued a decision in another case where the majority of the justices suggested that this area of the law was an anomaly. It was kind of an exception to the general First Amendment rule that the state may not compel speech. And, dues, when you pay union dues, you're really subsidizing speech. You're giving money to the union to speak on your behalf. Mm-hmm. And the ordinary First Amendment rule is that the state may not force you to support an organization with which you disagree. So once the Supreme Court flagged this as an issue that it was willing to reopen, we looked around as fast as we could to find a suit, to find some plaintiffs, to find a good set of facts, to get to the Supreme Court as fast as we could. We settled on California. It turned out to be very easy to find plenty of teachers in California who wanted to change this system. So within 6 months, really, we had a suit put together and we filed it.
Now, the Center for Individual Rights is what's known as a public interest law firm. What does that mean?
Well, we bring cases that individuals couldn't afford to bring on their own, but which serve the public interest. We primarily focus on cases involving individual rights. So when we win one of these cases, the benefit isn't so much for the particular individual, it's for the tens of thousands of individuals who benefit from the precedent that we set. So that's why these cases are in the public interest. No individual could really afford to bring one of these cases, and they end up benefiting tens of thousands of other individuals. So we were organized to bring exactly that kind of lawsuit, because if there wasn't a CIR, nobody would bring these lawsuits.
So, Rebecca, how does it feel to be a test case?
It's wonderful. It's liberating, because for 28 years I tried to make my voice heard. I tried within the union. I tried without the union. I tried as a parent. I tried as a community member. And I could not make my voice heard. So I feel very liberated that I actually have just a way to tell my story so that other people can hear the truth.
So, Terry, after you picked up this case, when and where did the litigation process begin?
Well, we filed suit in federal court in Los Angeles, and we asked the court to expedite the case because in our view, and in the view of everybody who looked at it, there's only one court in the country that could resolve this question, and that's the Supreme Court. The lower courts are really bound by prior Supreme Court cases where the court had upheld these kind of compulsory dues arrangements. And so we really had to get to the Supreme Court quickly because it was the only court that could provide our clients with the legal remedy that they desired. So we asked the district court to forego a trial and discovery and rule against us so that we could get quickly to the next level.
Wow, is that unusual?
It's been done before, but it is a little bit unusual. But in this case, it was the really only sensible way to proceed. Certainly, the district court wasn't eager to have a trial when there was only one way the district court could rule. So that trial would have served no purpose, and the judge agreed with us and sent the case on to the Ninth Circuit. We asked the Ninth Circuit to do the same thing, and we were gratified when the Ninth Circuit did that. And so we got to the Supreme Court in really a record amount of time. And the advantage of this is that it really presented the Supreme Court with a clean legal issue. Either compulsory dues are okay under the First Amendment or they're not. So that's the question that we brought to the court. It was a clear question, and the court, was ready to answer it.
Rebecca, did you become a pariah in the teacher's lounge once this case heated up?
I suppose I probably am. It's interesting because a lot of teachers agree with me, but they're just too afraid to speak out about it because you don't dare speak against the union when you're a teacher. So I've had many come to me quietly, but it's always in a dark closet or a dark room or after school when no one's around, and they'll thank me and they'll give me a hug. But there are some that are mad at me, mostly union representatives. So I definitely cause a little bit of controversy on campus.
Has there been any outright intimidation? Have your tires been slashed or anything?
That's been my biggest shock. That's what I was expecting. My family was expecting to have all kinds of retaliation like that, but we have not. I don't know if it's because there are cameras in our parking lot or not, but we have not had any of that type of retaliation. We've had a lot of nasty, emails and that sort of thing, but no retaliation.
Well, you know what? People have a right to speak their mind just like you do.
Mm-hmm.
Let's just play out. So, Terry, you're in front of the Supreme Court. You've got a minute and a half. Make your case.
Well, we're suing to end the laws in 23 states that force public employees to pay dues to support an organization with which they fundamentally disagree. In our view, collective bargaining is a highly political undertaking. The union takes very controversial positions about pensions, about seniority, about school choice that reasonable people can disagree about. And the state's job is not to force individuals to support one side of these contentious debates or the other side, but to allow each individual to decide for themselves whether to join the union or not join the union or join another organization or sit on the sidelines and not say anything at all. So that's what the First Amendment requires, and we're really asking the Supreme Court to rule that the states have to follow the First Amendment.
So how is it that the Supreme Court's gotten it wrong all these years?
Well, the Supreme Court basically decided that it was in the interest of the states to run an efficient collective bargaining system. And the Supreme Court was pretty conscious that this was an exception to the First Amendment. It knew what it was doing, and it thought this was necessary. But as the years have passed, it's clear that it's not necessary. In fact, there's a number of states that on their own, without the Supreme Court, have become right-to-work states. And it turns out the unions are thriving in those states. And the union leaders themselves say that when they have to sell themselves to members, when they have to go out and pitch what they are offering, they do better. They make a strong case. And look, a lot of teachers agree with the union, and that's fine. And they do join the union. They should be free to join the union. We're really fighting for the right of a handful of teachers, perhaps a minority of teachers, to not join the union. And that's okay, too. That's what the First Amendment is all about, allowing each individual to decide this question for themselves.
Well, it's very interesting. I certainly look back at my life. Telephone service sure has gotten better since they broke up the monopoly.
Well, I think that's right. I think in a lot of ways the unions have become what they used to fight against. They are large, entrenched institutions that get millions of dollars in coerced dues each year, and they're not accountable to anyone. The union leadership can take whatever political position it wants. It can continue to fight for higher salaries and gold-plated pension benefits even when the communities these teachers live in are going bankrupt. And that's what happens when an institution loses its accountability. If we make dues voluntary, as they should be, as the First Amendment requires, I think everybody's hope is that the unions will be more accountable to their members and they'll become better organizations as a result.
So, Terry and Rebecca, you argued your case before the full 9-member court, but Justice Anthony Scalia passed away before the court could render a decision. What impact did this have?
Well, it really stopped the case in its tracks, but it turns out this has happened quite a bit since, in the last 50 years. And what the court does, and what it's likely to do in this case, is it holds the case over until a new justice can be confirmed, and then we will re-argue the case, and then the full 9 justices will decide the case. And that's a good thing. I mean, these cases are important. We've spent a lot of money. The unions have spent a lot of money to get this case to the Supreme Court. There are laws in 23 states that hang in the balance here. The unions want a clear answer. We want a clear answer. So what the court does is just hold the case until the full 9 justices can decide it. That'll probably happen a year from now. So the practical effect is a 1-year delay and a re-argument. But that's, everybody understands the importance of deciding this.
But let me back up. I think it was in March they did issue a tie decision, right, just to sort of put on the record where they stood?
That's exactly right, and that's part of the procedure here, too. What they do is release a per curiam decision. There's no opinion written. It's just a straight statement that we are deadlocked. There's 4 votes on each side of this.
Interesting.
Yeah, no, and then that allows the parties to decide themselves whether they want to petition for a rehearing. And we filed that petition because we certainly want to have the case reheard so that we can get a decision on the merits with the full authority of 9 justices. So we filed that petition, and now we believe the court will basically sit on our petition until a 9th justice joins the court, and then they'll vote on it. If there are the votes to rehear the case, that's what will happen.
So no one has actually issued an opinion, and so you've gone on this whole process. It was a rocket up to the Supreme Court, and here you are now waiting for basically a political process to take place for the court to get its full 9 members.
That's exactly right. That's exactly right.
Well, it's very unlikely we're going to see a new Supreme Court justice before the end of Obama's term. So how do you want to handicap what's going to happen next year?
Well, obviously nobody has any idea who the new justice is going to be, but whoever it is, we will work hard to convince that justice to get them to vote our way. We think the merits of our case are strong. We had 5 votes, before Justice Scalia passed away. We fought for every one of those votes. In fact, Justice Scalia was against us when we started the case. So we don't take anybody's vote for granted, regardless who the new justice is and which party they're appointed by or which, what their political outlook is. We will fight for that person's vote. We think the First Amendment arguments are strong here, and we think they should be appealing to any justice, regardless of, where they come from. So we're looking forward to get rolling again when there's a new justice, and we'll argue it out and hope for an outcome in our favor.
So, Rebecca, are you now back in the classroom paying your dues?
I am. I'm still teaching, and I'm still paying my forced dues. And, I'm just hoping and praying that we will be able to re-argue our case because, sadly, a lot of teachers like myself are paying these dues to a union that is unaccountable to us. This union makes decisions really on behalf of the union leadership, not on behalf of the teachers, because they get coerced dues from us. They don't have to do anything to earn these dues. They get them no matter what they do. So, I am very hopeful that we will be able to re-argue our case and prevail so that we can give teachers across the country the choice to join a union if they want to join a union and pay the union if they like the union, and the choice not to join if they disagree with the union, so that they can stand and do what's right for their students and do what's right for their community and what's right for their families.
Speaking of that, are the kids and the parents aware of what's going on here, or has that all been invisible to them?
Yeah, it's interesting because I teach 3rd grade, so I don't talk about this with my students. They're really too young.
Sure.
But when we went to the United States Supreme Court, there was a lot of media coverage. So when I came back to work the following week, my students were, bug-eyed. Mrs. Friedrichs, I saw you on television. And they all had all these questions for me. So I just told them that I'm fighting for what I believe, and I explained to them the branches of government, and that I went to visit the United States Supreme Court, and that I shared my story, and that I'm fighting for what I believe is right. And the kids were so cute. One of my little students wrote me a note, "Dear Mrs. Friedrichs, I'm so proud of you for standing up for what you believe." So they get it.
So it was a real teachable moment for everybody.
It was, yes.
Well, Rebecca, thank you so much for joining us. Terry, thanks for coming on the show, and let's see what happens next.
Thanks for having us.
Thank you for helping us tell our story.
That was California third-grade teacher Rebecca Friedrichs and attorney Terry Pell, president of the Center for Individual Rights, here on Real Clear Radio Hour, brought to you by the Competitive Enterprise Institute. I'm your host, Bill Frezza. Real Clear Radio Hour is a not-for-profit, donor-supported program produced in conjunction with Real Clear Politics, America's premier independent political website. To make sure you don't miss any of our shows, stop by realclearradio.org and sign up for updates. And if you'd like to support more thoughtful programming like this, please hit the donate button or contact us to become a corporate supporter. Today's program was partially underwritten by the generous support of Old Boston Restorations, Victorian property management company in Boston South End. Visit them online at oldbostonrestorations.com. That wraps up our show for this week. Please join us next week, same time, same station. See you then.